Hello, this is Matt on the Moon Lambo channel, and there has been what I would characterize as a rather shocking admission from an SRC commissioner who is acknowledging that there is not sufficient regulatory clarity in the crypto space, specifically identifying what makes something a security or non-security. And one of the reasons this is particularly astonishing, just to be super duper clear, this is one of five, this person in question is one of the five SEC commissioners who voted on whether or not to bring a legal complaint against Ripple, claiming that they sold XRP as an unregistered security. Now, I don't know how this individual voted for sure. It hasn't been made public. My understanding is that that information will be made public once the case is either settled or fully adjudicated, but right now we don't know. My guess, and I could be wrong, but my speculation would be that she would have voted against the complaint being brought against Ripple, but don't know for sure. Either way, this particular commissioner has made it clear that there's a lot of confusion in the market, and this is crucial. Like, I'll tell you what, if I'm a an attorney for the SEC, I'm like, oh my gosh, Commissioner, shut up. That's what I would be thinking right about now, because I don't know what the legal implications of this are. If comments like these, if you can bring it up in court, if it's admissible, or if it has to go through the discovery process, I don't know, because I just don't have a legal background. But I can tell you from the layperson's perspective, these arguments are very damning to the SEC and very supportive of Ripple's case, which is simply that, well, no, I shouldn't say simple. The point's simple to understand, but there are a lot of points. There's a lot of information to it. But the idea that the legal argument actually that Ripple is making, which is simply that they've been operating in broad daylight for the better part of a decade, and the SEC never took action against them until so many years later, late December 2020. Finally, this complaint came down. And how was Ripple supposed to know that what they were doing was wrong all this time, while the SEC, through their inaction, allowed the problem to get bigger and bigger and bigger and bigger, and more XRP was sold, and more XRP was sold, and more people are affected? Why would the SEC allow this? And really the truth is, they weren't convinced that XRP was being sold as a security. That's what I think, anyway. So look, before I go further, I want to be clear. I don't have a legal or financial background of any kind. I'm not offering legal or financial advice, and you should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos as a hobby. And so here is an article from the Block Crypto titled, SEC finds ICO rating website for taking money from issuers in exchange for better reviews. So I'm going to run through this real quick, and then I'm going to get to the real meat of it. Hester Peirce is the SEC commissioner in question, and she released this and she worked on it with Commissioner Elad Roisman. Elad Roisman is actually one of two acting chair people before Gary Gensler was appointed. And so you've got Hester and Elad, and they wrote this together. It's titled, In the Matter of Coin Schedule. And it gets directly at what we are talking about, at the heart of the Ripple case. It's just shocking. You can have the SEC saying, no, there's absolute clarity, and then you have a commissioner who voted on this, and we don't know how she voted to bring the case, whether she said yay or nay, but she's saying the exact opposite of what the SEC attorneys are arguing. It's truly astonishing. And this piece real quick, though, from the Block Crypto. On July 14th, the U.S. Securities and Exchange Commission unveiled settled charges against UK-based CoinSchedule. Accessible in the U.S. from 2016 to August 2019, CoinSchedule was a platform that reviewed upcoming initial coin offerings, providing seemingly objective perspective as to which ICOs were more or less scammy. Per the SEC's order, quote, the platform claimed to list or profile the best token offerings, such as so-called initial coin offerings and initial exchange offerings, and stated that its mission is to make it easy and safe for people around the world to join ICOs. End quote. Now, meanwhile, CoinSchedule was taking payment from issuers in exchange for more favorable reviews. I don't like that one bit. Anyway, failure to disclose such payments violate the anti-touting provisions of the Securities Act Section 17B. The terms of the settlement are, however, quite merciful. CoinSchedule's operator goes unnamed in the SEC's charges and will have to pay disgorgement and fines totaling roughly $200,000. Moreover, CoinSchedule was able to, this is a broken sentence, but they wrote able to without admitting to or denying the SEC's charges, and I think what they were trying to say is CoinSchedule, as a part of the arrangement here, didn't have to admit that they did something actually wrong, so yay them. But it sure as hell looks like they did, actually. And so then there was this tweet from Hester Peirce, SEC commissioner, who wrote on Twitter, "We still need crypto clarity." Well, SEC disagrees, right? Well, the rest of the SEC, right? She's part of the SEC. And then, so this is titled, "In the Matter of Coin Schedule." And it reads as follows. Let me jump down a little. I'm not going to cover the whole thing. But there is a decided lack of clarity for market participants around the application of the securities laws to digital assets and their trading, as is evidenced by the requests each of us receives for clarity and the consistent outreach to the commission staff for no action or other relief. Yeah, exactly. So if there was a clear outline how to do this, how to go to market, if you're in the blockchain world and you want to implement a cryptocurrency and some sort of technology, the degree to which people are asking for no action letters or other relief, it clearly would not be as high as it is. So the SEC pretending like they've added sufficient clarity, they know they haven't, and they don't care. These are not good people. I'm not saying Hester, I'm a fan of Hester, to be clear, though. In fact, I admire her for going against the grain here, because I can only imagine the internal strife this must be causing for some, especially if you're an SEC attorney, like, oh my God, Hester, what are you doing? So I actually admire this, and I don't think that people should. Some people are giving her a tough time. I'm just like, man, chill out. She's absolutely correct. And again, and I'll say that even if I find out that she voted to bring the action against Ripple, which, okay, I'd be surprised. Even if that happens, I'm still going to say she's right on this topic either way. Anyway, let's continue though. The test laid out in SEC versus WJ Howie Co. is helpful, but often, including with respect to many digital assets, the application of the test is not crystal clear. What's that heresy? Oh my gosh. Although the commission staff has provided some guidance, the large number of factors and absence of weighting cut against the clarity the guidance was intended to offer. So market participants have difficulty getting a lawyer to sign off that something is not a securities offering or does not implicate the securities laws. They also cannot get a clear answer backed by a clear commission level statement that something is a securities offering. So think about that. Even if you go to the SEC and say, hey, is this okay what I'm doing? Like Ripple did because they were transparent and had weekly talks with the SEC. Even if you do that, they won't give you their blessing. They're not participating. And so anyway, let's continue now. The industry, through efforts like the Crypto Rating Council's framework to consistently and objectively assess whether any given crypto asset has characteristics that make it more or less likely to be classified as a security under the U.S. federal securities laws, has sought to play a constructive role in providing clarity, but the Commission has to engage more. In this void, litigated and settled commission enforcement actions have become the go-to source of guidance. People can study the specifics of token offerings that become the subject of enforcement actions and take clues from particular cases. However, applying those clues to the facts of a completely different token offering does not necessarily produce clear answers. Providing guidance piecemeal through enforcement actions is not the best way to move forward. If the Commission intends to do so, then we should at least be clear about which tokens we have identified to have been sold pursuant to securities offerings. And so right there, it's Hester saying what we already all know to be true, and I'm thankful she's saying it, because she's in an important position in the SEC. She is saying quite clearly here, that the SEC is regulating through enforcement rather than actually having thoughtful guidelines and policy. It's not about that. It's about, you did something, now we decided we don't like it. Here's fallout for you. Good luck everybody else in the space. Deal with it. Figure things out. You don't know what we're thinking, but there you are. And so continue here. The coin schedule order tells us only that some unspecified quantity of the 2,500 tokens provided on CoinSchedule's website were offered or sold as securities. The order therefore provides no useful information to market participants either about which or how many of the 2,500 listed token offerings the Commission has determined to be securities offerings, or about the reasoning underlying those determinations. Exactly, which is why I started with this article here about CoinSchedule, because this has been settled, but you can look at this, and if you're trying to be like, okay, well, we don't like that they're regulating through enforcement, but the SEC is doing that, what can we learn from this? Oh, functionally nothing, because they didn't say which coins were problematic and which ones weren't. You can learn nothing from this. But the SEC, they got their money, didn't they? $200,000. It's just disgusting what's going on here. It could not be more clear that the SEC is not operating in good faith. Absolutely not. It's just a disgusting power grab and a money grab, and that's why, again, I appreciate what Hester is doing in thoughtfully and respectfully bringing this to attention. But again, I'm willing to bet, because I know humans. I do know humans. I'm a 38-year-old man. I definitely had time to get acquainted with humans, and in an organization like this, I would certainly expect that some people are none too pleased, but she keeps speaking out, and that's a bold move, and she's doing the right thing, along with Elad Roisman here. So fantastic seeing this. We'll see what comes of it, but I am really hoping that this is brought up in the SEC versus Ripple case. So wait, you're saying, Mr. SEC lawyer, that we had clarity. Well, what about Hester Peirce and Elad Roisman over here say, no, there actually isn't sufficient clarity. What about that? You know, SEC talking out of both sides of your mouth effectively, right? Because they're all part of the SEC. Like, to me, this stuff matters. And again, I don't know what the legal implications are, but just as a regular person seeing how both parts of the SEC are acting, they're incongruent, right? So how the hell could it be that the SEC believes that there was sufficient notification? I don't believe it I don't buy it. I just don't buy it. It's disingenuous. These are bad people. Not Hester and Elad. I'm not saying that. But these lawyers in particular, it's just slimy. I don't like it. I'll wrap up there, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.